When choosing to establish an estate plan in Illinois, do I want a will or a trust-based plan? Hi, I'm Steve Fagan, an Illinois estate planning attorney with the law firm of Fagan, Davis. Let's dive into the differences between an estate plan, centered around a last will and testament, versus a trust plan. Whether you go with a will or a trust, at a minimum, any responsible estate plan should include a power of attorney for property, a healthcare power of attorney, HIPAA waivers, and finally, a living will, also known as an advance directive. Without these elements of an estate plan, you're just leaving far too much in limbo and subject to the decisions of others. A will, or last will and testament, is an instrument that tells the probate court how you want your property disposed of after your debts are paid. Without a will, it's up to the probate court to apply Illinois law to make those decisions. And that means you don't get any say. Establishing a will-based plan is certainly a giant step in the right direction, given that we've heard estimates that some 75% of people have no estate plan whatsoever. The downside of the will-based plan is that your estate will have to go through the very public probate court process. Because your estate is being decided by the court, that process can almost seem like an invitation to litigation. In fact, an important part of the process is publication of the probate, specifically to invite any creditors or objectors. In Illinois, the probate process typically takes about 14 months at a minimum, and court costs and attorney's fees can build into thousands very rapidly. So what about a trust? Think of a trust-based plan as a way to place your assets into a container for the benefit of someone both now and once you pass. You can retain a lot of direct control with something like a revocable trust, or less direct control but have a great deal more protection from things like taxes, creditors, litigation, and certain types of trusts called irrevocable trusts. In fact, there are a lot of options. The most fundamental benefits to a trust-based plan are avoiding the long, drawn-out wait for your estate to go through the probate process before your property can be used the way you intend, privacy, because your estate doesn't go through the public court system, the contents of that container we mentioned stay private, and finally, the ability to limit and control costs rather than the unknown and uncontrolled potential expenses that can come with the probate process. There are certainly other potential benefits to some more advanced trust plans, such as tax planning, protection of assets from potential litigation, planning for loved ones with special needs or Medicare and more. But that's a topic for another video. I hope that gave you some ideas about the differences between wills and trusts in Illinois. You can learn more in our other videos and at our website at myattorneysonline.com. Again, thanks for joining me. I'm attorney Steve Fagan. Feel free to check out our other videos for more information. If you want the peace of mind that comes with developing the right estate plan for your future, call or text us at 847-635-8200. That's 847-635-8200. You can call or text us anytime.